Start. In Narinder Singh versus State of Punjab 2014, a two-member bench of Honorable Supreme Court holds thus we found that in certain circumstances this court has approved the quashing of proceedings under section 307 IPC, whereas in some other cases it is held that as the offence is of serious nature, such proceedings cannot be quashed. Stop. Though in each of the aforesaid cases, in view taken by this court may be justified on its own facts, at the same time this court owes an explanation as to why two different approaches are adopted in various cases. Stop. The law declared by this court in the form of judgments becomes binding precedent for the high courts and the subordinate courts to follow under Article 141 of the Constitution of India. Stop. Stare decisis is the fundamental principle of judicial decision making, which requires certainty to in law, so that in a given set of facts that the course of action which law shall take is predictable. Stop. Unless that is achieved, the very doctrine of stare decisis will lose its significance. Stop. The related objective of the doctrine of stare decisis is to put a curb on the personal preferences and priors of individual judges. Stop. In a way, it achieves equality of treatment as well, in as much as two different persons faced with similar circumstances would be given identical treatment at the hands of law. Stop. It has therefore support from the human sense of justice as well. Stop. The force of precedent in the law is heightened in the words of Karl by that curious, almost universal sense of justice which urges that all men are to be treated alike in like circumstances. Stop. As there is a close relation between the equality and justice, it should be clearly discernible as to how the two prosecutions under section 307 IPC are different in nature and therefore are given different treatment. Stop. With this ideal objective in mind, we are proceeding to discuss the subject at length. Stop. It is for this reason we deem it appropriate to lay down some distinct, definite, and clear guidelines which can be kept in mind by the High Courts to take a view as to under what circumstances it should accept the settlement between the parties and quash the proceedings, and under what circumstances it should refrain from doing so. Stop. We make it clear that though there would be a general discussion in this behalf as well, the matter is examined in the context of offences under section 307 IPC. Stop. In view of the aforesaid discussion, we sum up and lay down the following principles by which the High Court would be guided in giving adequate treatment treatment to the settlement between the parties and exercising its power under Section 482 of the Code while accepting the settlement.